In this lecture, we will discuss about the amendments provisions of the Constitution as provided under Article 368 of the Constitution of India. So, before that, in our introduction, we would like to discuss the very pronouncement of Pandit Jawaharlal Nehru, who was as a member of the Constituent Assembly in the Constituent Assembly debate. Nehru expressed that the Constitution being the fundamental law of the land should also be like that. While we want this Constitution to be as solid and permanent as we can make it, there is no permanence in constitutions. There should be certain flexibility. If you make anything rigid and permanent, you stop the nation's growth, the growth of a living, vital, organic people. In any event, we could not make this constitution so rigid that it cannot be adapted to the changing conditions. When the world is in turmoil and we are passing through a very sweet period of transitions, what we may do today may not be wholly applicable tomorrow. So, in that context, we would like to discuss the saying of Hermann Feiner in his book Theory and Practice of Modern Government, where in Hermann Feiner defined constitution as the process of amendment, for in his view to amend is to disconstitute the reconstitute. He considered the amending clause so fundamental to a constitution that he called it the constitution itself. Many other eminent authors have expressed similar views, realizing that the amending process was the only guarantee of a constitution, leading itself to meeting the changing needs and requirements of a society yet to develop. The Indian Constitution makers also provided a procedure for amendment, and that was made the 20th part of the Constitution of India, and the very provisions of amendment, as we found, mixed, as some part provisions were borrowed from the Constitution of United States of America, and also some provisions from the Canadian Constitution, also from Australian Constitution. So that's why the Indian Federation is called as quasi-federal in nature. So now discuss the provisions of Article 368 as regarding Clause 1, the very procedure for amendment as it was inserted under 24th Amendment Act of 1971. So, Article 368, which dealt with the procedure for amendment of the Constitution provided that a bill for that purpose could be initiated in either House of Parliament and not in any state legislature. So that exactly we found as mentioned why William B. Monroe in his book regarding the government of United States where he mentioned that the very provision regarding amendment could be initiated in either House of Parliament and not in any state legislature. And when the bill was passed by Parliament, it should be presented to the President for his assent. Upon such assent being given to the bill, for which no time limit had been prescribed in the Constitution, then the Constitution stood amended in accordance with the terms of the bill. Certain provisions of the Constitution could be amended only if they were passed in each house by a majority of the total membership of that house and by a majority of not less than two-thirds of the members of that house present and voting, and thereafter were ratified by the legislature of not less than one half of the state by resolution to that effect passed by those legislatures before the bill was presented to the President for assent. Those provisions now we would like to discuss as such. Article 54 relating to the election of President, Article 55 relating to the manner of election of President, Article 73 relating to the extent of executive power of the Union, Article 162 relating to the extent of executive power of states, or Article 241 relating to high courts for union territories, and also Chapter 4 of Part 5 relating to the Supreme Court, Chapter 5 of Part 6 relating to high courts in states, or Chapter 1 of Part 11 relating to distribution of legislative powers between the union and state. So any of the three legislative lists in the seventh schedule, and also the representation of states in parliament, even the provisions of Article 368 itself relating to the amendment of the Constitution. These were by and large federal provisions, that is, provisions in which both the Union and the states were involved. So a former Chief Justice of India, Justice K. Subba Rao, called them the entrenched provisions of the Constitution. And as regarding the remaining articles of the Constitution, except 22 articles which could be amended by Parliament by a simple majority, could be amended by a majority of the total membership of each house, and by a majority of not less than two-thirds of the members of that house present and voting. These 22 articles dealt with such subjects as Parliament's power to make any provision with respect to the acquisition and termination of citizenship and all other matters relating to citizenship, the creation of new states or the reconstitution of existing states, abolition or creation of upper chambers in states, and provisions as to administration and control of scheduled areas and scheduled tribes. Also, scheduled fifth part D. Then the salaries of Supreme Court judges as provided under Article 125 and so on. The laws passed by Parliament to change these provisions would not be deemed to be amendments of the Constitution for the purposes of Article 368. So now we'll discuss exactly the provisions of amendment as provided under Article 368 and as it relating to the very clause 1 and clause 2, so also relating to clause 3 and 4 and 5 of the Constitution, and as relating to this clause 3 of the Constitution, amendment as provided under Article 368 was inserted under 24th Constitutional Amendment Act 1971, which exactly provides that as per the provisions, nothing in Article 13 shall apply to any amendment made under this article. And as regarding Clause 4 and Clause 5, which were inserted as per 42nd Constitutional Amendment Act 1976, which amended as such, the very amendment is that under Clause 4, no amendment of this Constitution, including the provisions of Part 3 made or purporting to have been made under this article, whether before or after the commencement of Section 55 of the Constitution, shall be called in question in any court on any ground, and the Clause 5, which also inserted under 42nd Constitutional Amendment Act of 1976, provides for the removal of doubts. It is hereby declared that there shall be no limitation whatever on the constituent power of Parliament to amend by way of addition, variation, or repeal the provisions of this Constitution under this article. So, there is a bar on judicial review as for these amendments and insertion of Clause 4 and 5 under 42nd Constitutional Amendment Act 1976, so it was challenged. So, in the important leading case, that is Minerva Mills Limited versus Union of India, the Supreme Court pronounced that Clause 4 and 5 of Article 368 are ultra vires because they exclude judicial review, which is a basic feature of the Constitution, as it was pronounced in this important leading case by the Supreme Court. So, striking down Clause 4 and Clause 5 of Article 368, the amending article, as inserted under the 42nd Constitutional Amendment Act 1976 as ultra vires. So now we'll discuss certain important amendments as such. The first Constitutional Amendment Act of 1951, which inserted the ninth schedule to the Constitution. As we know, the original Constitution of India was consisting 22 parts and 8 schedules and 395 articles. So the ninth schedule was inserted under First Constitutional Amendment Act by giving protection of land reform legislations of all states were placed under the ninth schedule of the Constitution, which would be beyond judicial review. And now we'll discuss another important amendment, and that is the 39th Amendment Act of 1975, whereby a new article was inserted as Article 329A, only due to the very judgment delivered by the Allahabad High Court, whereby declaring the very election of the then late Prime Minister Indira Nehru Gandhi as invalid. So, by that declaration, the Prime Minister, the then late Prime Minister Indira Nehru Gandhi brought a new amendment to the Constitution of India by inserting Article 329A, which relates to the election of President, Vice President, Prime Minister of India and the Speaker of the Lok Sabha would be beyond judicial review. As per this amendment, the 39th Amendment of 1975. So, now we'll discuss one important leading case, that is Shashank Shekhar Maity versus Union of India. In 1981, the Supreme Court delivered an important judgment so relating to that the pronouncement of Supreme Court the power under Article 368 as per the pronouncement of Supreme Court in this particular leading case is a constituent power not subject to constitutional scheme as to distribution of legislative power according to entries in 7th schedule. So, this is an important ruling made by the Supreme Court in relation to the constituent power of Parliament. And now we will discuss the basic structure or the basic feature concept and the relationship it with amendments to the Constitution. So, the very concept of basic features or basic structure of the Constitution, no doubt initially it was pronounced in the important leading case ADM Jabalpur versus Sipkan Shukla in 1976. But the real credit would go to Kesavananda Bharati versus State of Kerala in 1973, where the learned judges of our Supreme Court pronounced certain provisions of the Constitution of India as basic structure or basic feature of the Constitution which could not be amended by the Parliament. So, in that regard, we would like to discuss one most important judgment of Supreme Court in 1993 in the leading case, Kyoto Holohan versus Jachilu, where it was held that elections free and fair should show sovereign democratic republican structure of the constitution or the basic structure or basic feature of the constitution as it was pronounced by our Supreme Court. So also we would like to discuss another important leading case, Subhash Sharma versus Union of India in 1991. The Supreme Court expressed that judicial review is also the basic feature or basic structure of the Constitution. So also we'll discuss another important ruling of 1993 in the most important leading case, Indra Sahani versus Union of India, where it was pronounced that rule of law is a basic feature or basic structure of the Constitution. And now we'll discuss another important ruling of Supreme Court relating to Delhi Judicial Service Association of this Hazari Court versus State of Gujarat in 1991. The Supreme Court expressed that powers of the Supreme Court under Articles 32, 136, 141 and 142 are the basic features and basic structure of the Constitution. So also in the most important leading case, Indira Nehru Gandhi versus Raj Narayan in 1975, the Supreme Court pronounced that fundamental rights is a part of basic structure of the Constitution. And now we'll discuss the ruling of another important judgment made by the Supreme Court in 2013 relating to Namit Sharma versus Union of India, where it was held that the dignity of the individual secured by the various freedoms and basic rights contained in Part 3 of the Constitution and their protection is the basic structure of the Constitution as it was pronounced by the Supreme Court. So now we'll discuss another and the most important judgment by Supreme Court in 1993 and that is relating to Kyoto Olohon versus Yachilu, where the very question was raised as per the provisions according to B and subsection 2, an amendment of the Constitution which takes away the powers of Supreme Court as under Article 136 or of a High Court, say under Article 226 shall be void unless it is ratified by the legislator, not less than one half of the states before being presented to the President for his assent. So, The very word change at the beginning of the provision means a change in the remedy while the right remains intact. But such change may not be a direct change in the language of any of the provisions specified in Clause A to Clause E of the power provisions, but may be a change in effect. So, why particularly defining the scope and jurisdiction of effect? So, at instance of a Supreme Court, a constitutional amendment in effect changing Article 136 226 to 27 is to be found in the judgment of the Constitution Bench, where the validity of paragraph 7 as inserted into the Constitution under 10th schedule of the Constitution by the 52nd Constitutional Amendment Act 1985 was challenged by the petitioner. In this particular leading case, Kihutu Uloan versus Jajulu, whereby their lordship, applying the very doctrine of severability or separability, they separated the very paragraph 7 of the 10th schedule of the Constitution, which was inserted under the 52nd Constitutional Amendment Act, and it was declared as invalid as the very paragraph 7 was relating to that the anti-defection laws and such laws relating to defections of members of parliament or state legislatures defecting from one party to another and duly elected by one party and leaving that party and defecting to another party, and such provisions of under paragraph 7 could not be challenged in any court of law and it was beyond judicial review. So that very paragraph 7, by applying the doctrine of severability and doctrine of separability, the Supreme Court of India declared invalid of that very part, paragraph 7 of 10th schedule dealing with defection laws. So, by that we have completed the amending provisions of the Constitution of India as provided under Article 368 of the Constitution of India, and in due discussion in this lecture we have discussed the very pronouncement made by the then late Prime Minister of India, Pandit Jawaharlal Nehru, in the Constituent Assembly regarding amending provisions, and also in detail we have discussed all the relevant, important Supreme Court pronouncement in connection to all those important leading cases, and the very important leading case such as Indira Nehru Gandhi versus Raj Narayan, Minerva Mills Limited versus Union of India, Keswananda Bharati versus State of Kerala, and also Kyoto Huluwan versus Jachilu, one of the important leading cases decided by the Supreme Court in 1993. So, with this, we have completed our lecture on the amendment to Constitution of